The Senate reconvenes to continue the screening of presidential nominees as resident electoral commissioners. In a committee of the whole, the Senate screens the nominees from Lagos, Rivers and Zamfara states, questioning them on various aspects of election management and subsequently asking them to take a bow and leave.
The Senate approved the nominations as follows. Dr. Bumi Omesheindem for Lagos State, Dr. Onubum Onoha from Rivers State, Mr. Abubakar Fawa Dambo from Zamfara State, as resident electoral commissioners Rex. For the Independent National Electoral Commission INEC, those in favor of the confirmation say aye. Those against say nay. The ayes have it.
7 nominees were earlier screened by the Senate, bringing the total number of confirmations to 10. The nominations were, however, greeted with controversy by some members of the civil society organizations, criticizing at least 2 of the nominees.
These are individuals who are really out there in public who have professed their political preference and alignment. And we've been screaming and shouting and advocating and telling our politicians that there is grave danger when INEC is populated by politicians.
The People's Democratic Party particularly condemned the appointment of Mr. Etekamba Omoren from Akwa Ibom State and Mr. Issa Ehimiane from Edo State, describing it as provocative.
The PDP, therefore, in clear and unequivocal terms, reject the imposition of Etekamba Omoren as INEC rep in Akwa Ibom State, being conceived in iniquity and in a flagrant violation of the express provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the universal demand of impartiality and non-partisanship of an electoral body and its officials.
However, the Senate says there is a leeway for a review if any petition is presented.
No Nigerian is wrong for calling for either a recall or upholding of whoever that is screened, because everybody has right either to complain, either to pass comment, either to ask questions, but it has to be properly done.
So you did not receive any petition?
No. If prior to the appearance of these nominees for Senate, there have been petitions, there have been security reports suggesting that they could be compromised, or suggesting that they are not fit because they are going to handle electoral matters. Definitely they should not have political parties that they belong to. Then definitely the Senate will look. But the afterthought criticisms, the afterthought reasons why we should not do this and why we should not do that, does not arise. All these names were just in public domain. So it's not for us, it's not for me, it's not for anybody to suggest that you are likely to be a member of a party. It's not for me, it's not for anybody to do. That whoever has the fact is supposed to bring the fact before the Senate.
He also explains why the Recs were not screened at the committee level.
We want to do it openly so that Nigerians will see them and then they will talk before Nigerians and then everybody.
He firmly assures that when a petition is officially presented, the lawmakers will accord them paramount consideration. From the Senate, Gloria Umezuke, Channels Television News.
Well, thank you so much for staying with us on the program. And that's where we begin with. You can see that a good number of issues were raised in that report by my colleague, Gloria. But let's start with the need for electoral reforms this morning, particularly what many people adjudge to be a skewed appointment of INEC Rex, which has party members or supposed party members confirmed. Mr. Femi Falana joins us, as you see in that welcoming slide. He's a senior advocate of Nigeria. Thank you for joining us again.
Thank you very much.
Well, the INEC Rex, you know about that. I mean, the Supreme Court has ruled on such things before. The Constitution is very clear on that part in the third schedule. It should be non-partisan and all. One of the questions that I asked yesterday, our guest, who is also a legal practitioner, was, Could the president have missed it? Could the Senate have missed it? But of course, he said he couldn't have missed it. But the question that I'm asking you is, what do you make of it? How does it help the integrity of INEC? Is INEC independent? So many questions to ask. One finds it difficult to even pin it to one.
Well, since 1999, we've had this terrible experience of a ruling party trying to people the electoral body with party loyalists and sympathizers. And that was what led to the amendment of the Constitution. I mean, it will interest you. The APC, and the civil society organizations were complaining against the appointment of members of the ruling party, that is, the PDP then. As a matter of fact, the bitter experience of our country led the Mohammed Uwais panel to recommend that the chairman or the chairperson, national commissioners of INEC, and resident electoral commissioners be appointed by advertisement. In other words, you invite candidates who would like to serve the nation at that level, and then the National Judicial Council was recommended to shortlist the best three and then send to the Senate via the Council of State, because the Council of State is required to advise the president on the choice of electoral chiefs. But that was not adopted by both the PDP and the APC. So you have this problem again. With respect to the last appointment, for me, the last has not been said about it. It has been shown without any challenge that 4 out of the 10 resident electoral commissioners recently appointed by the president and who have now been asked to take a bow, as it were, in the in the Senate, are card-carrying members of political parties. 3 of them are APC members, while the 4th one is a member of the PDP. I think, happily, the Akwa Ibom state chapter of the PDP went to court yesterday to sue over the appointment of Mr. Umoren, former chief of staff to the Senate president, the current Senate president, Senator Akpabio, and the chieftain of the APC in Akwa Ibom State. So the PDP has gone to court. I also expect others to go to court to challenge the appointment or the competence of the 3 others.
Even though the Senate has confirmed?
No, it doesn't matter. Once an appointment is illegal, there's no confirmation that can legitimize it. Because we must begin, right? The commitment to have credible elections in 2027, the shame of bad elections in Nigeria must stop. And President Tinubu holds it a duty not only to encourage INEC to conduct good elections, he must also ensure that his own promise to have credible elections in Nigeria is fulfilled. As a matter of fact, since 2007, successive regimes in Nigeria, Yar'Adua regime, Jonathan regime, Buhari regime, have all set up electoral reform committees or panels to make recommendations that will assist the government to have credible election. In the case of President Tinubu, as a candidate, as a leader of the ACN, Asiwaju Bola Ahmed Tinubu set up a committee, committee for, electoral reforms, to campaign for the implementation of the recommendations of the Uwais panel. And one of them is that we must have independent umpires in every material particular. You can't have a card-carrying member of a political party or a loyalist of a party to be a resident electoral commissioner or a national commissioner. You complicate the problems for INEC to have credible elections.
So anyway, I'll leave all of that one because it's even difficult to conjecture sometimes. But another rather troubling one is there, and I know that maybe Marquez and Chamberlain will come back to this one. But another troubling one is the fact that electoral cases, the validity of those cases moved from the polling units to the courts. It sounds or comes across to a good number of people like after we have voted, votes counted, and INEC has made the announcements, the final, should I say, unauthorized electoral college, so to speak, is the courts that will now determine whether or not the election held at the polling units were substantive or not. Now, you spoke to the Supreme Court decision before then, and you made, it sounds like, look, well, let's just see what's going to happen, but you really weren't expecting much change. In that situation, where the courts are the one that tend to decide. For instance, Natasha Akpoti, has also just been confirmed as the winner of
senatorial
seat when someone else had initially been sworn in. So all these issues, and a good number of them have been upturned like that. When does that end?
Where it's going to end is the determination this time around of all stakeholders, lawyers, judges, political leaders. We need to resolve that never again are we going to allow judges to determine or confirm the results of election. It doesn't happen anywhere in the world. And that is why I've repeatedly challenged my colleagues. Are you aware that we have the largest number of election petitions in the world? In fact, it may surprise you. Contrary to the information or the impression out there, this year we recorded almost the lowest number of election petitions since 2003. 436 petitions. In 2019, we had 807 election petitions. In 2007, the worst election we have ever conducted in Nigeria, Nigeria recorded 1,282 election petitions. But what will surprise you, and this is why, frankly speaking, apart from late arrival of materials, snatching of beavers machines in certain areas, and the failure of INEC to transmit results from polling units to his central server. Frankly speaking, those are the allegations against INEC. With respect to the political class, members of the political class are not prepared for credible elections. And we must interrogate that. What I mean is this. The management of pre-election matters. I'm talking of mismanagement of primaries of the parties. led to a situation where 1,878 cases were filed in the Federal High Court, pre-election cases. So for months, the Federal High Court, majority of the Federal High Court judges could not handle any other matter. 2. In Ekiti, under Governor Fayemi, in Imo State, under Governor Okorosha, in Katsina State, under Governor Masari, in Oyo State, under Governor Makinde, and others. The Supreme Court has declared illegal the dissolution of democratically elected local government councils and replacement with appointed caretaker committees. But up till now, the governors still continue to dissolve local government, still continue to appoint caretaker committees currently in just the Plateau State. The governor there, I think, is a lawyer of not less than 30 years. There is a court order, thou shalt not dissolve democratically elected council. It dissolved them and appointed caretaker committees. We have that in about 8 states now. And okay, some of them say, okay, we are going to hold credible election. Don't worry, you say we should be holding election. We'll hold them. What happens? The members of the state independent electoral commissions conduct the worst elections anywhere in the world, where the chairmanship candidates and the councillorship candidates of the ruling party in every state must win all the elections. So you must therefore go back to the drawing table. Instead of blaming INEC alone for the crisis that we are going through, to what extent are leaders, political leaders, prepared to embrace democracy?
Does that then mean that the state independent electoral commissions are not independent?
Oh, nobody says they're independent. Nobody says that. Nobody. That is why the candidates of opposition parties can never win election in any of those states.
Are they not supposed to be independent?
They are under the constitution. They are independent on paper. But in practice, this is what you are just going through now. Once you appoint your political party members or agents as members of an electoral body, what do you expect?
Okay, now, part of what you were saying the other time when you talked about the Supreme Court making its mind up about some things in the electoral, commission and the electoral reforms and all, there have been suggestions, and I know you have heard them, that we should have elections. Those conversations have been coming up since the Supreme Court ruled that we should conduct elections and resolve all electoral disputes before the swearing in of whoever is going to be president or governor.
It's not a fresh suggestion. Again, that is one of the recommendations, one of the principal recommendations of the Mohammed Owais panel, i.e., that we should conduct elections at least 6 months to the inauguration of the incoming government, whereby all election petitions will have been concluded. And we have no choice, because it is ridiculous to have governors, the president, legislators, and others in place, only for them after 6 months, 8 months, or 10 months to be removed. It's wasteful, and it doesn't portray us as serious people before the world. So we must therefore go back to the implementation of those remaining recommendations of Owais panel. One of it is conclusion of election petitions before the inauguration of new government. Secondly, we must have in place an electoral offences commission to deal with those who violate the law, those who commit Serious crime during election, before, during, and after election. Those who manipulate results, those who engage in thuggery and violence.
Okay.
Because if you allow the ruling parties, either at the federal or state level, you won't get anything, because the attorneys general usually are in the habit of filing nolle prosequi. We don't want these thugs prosecuted. Even the last election, somebody was arrested in Rivers State with humongous sum of money. I think about $500,000. It was charged. The state government has discontinued the case.
I know my colleagues want to come in on this one, but if the chief law officer of a state is saying that he's doing the things that you're talking about, then who is going to take him up? How does this trend end?
Only his appointer. Only the president or the governor that appointed him or her can take it up. But if we're talking of party alliance, and that was why the panel made that recommendation. There should be an independent body to deal with electoral offenses. But what did the National Assembly do? What has the National Assembly done since then? Is to say, INEC, you prosecute, knowing that INEC does not have the capacity to prosecute. And that leads to the other recommendation by the panel, by the West panel, that we must unbundle INEC. We must have a political party registration commission. We must have an electoral offenses commission. Of course, we have INEC to conduct election only. Okay. The other one that you mentioned, that's apart from concluding election petitions before the inauguration of government, we must also add now that we must conclude all pre-election cases before the election. In other words, who is qualified to contest election, who has won a party primary, and so on and so forth. Because it is wasteful, it's incongruous, and rather funny that when somebody is in office who has been voted for by the people, you now wake up and say, sorry, he should not have contested the election because he wasn't qualified or he didn't win the primary. Where should that be after the electorate, after the people have decided this is our choice?
Okay. Chamberlain.
Morning, Mr. Falana. Well, part of what several persons have suggested following the cases from the Supreme Court, some say the way it does appear now, it comes across as though we're always putting INEC on the defensive with the cases that they have to join them in court. And they then suggested that either we make them an independent body, and some others think it may not be a bad idea if we probably shift the burden of proof on INEC so that they don't always come across as though they're defending whatever it is that might have happened. Will this be a good one?
Chamberlain, I think my colleagues should not give the impression that they are making new suggestions. It's not fair to give the impression that these are new suggestions. Again, if we go back to the Ways panel, this is one of the recommendations that INEC the onus should shift right now. The onus is on the petitioner to prove that INEC has not substantially complied with the law or prove beyond reasonable doubt that allegations made are proved. And upon a review of the electoral system, the Ways panel recommended a new electoral jurisprudence whereby once you can show that the election has not been properly conducted, not beyond reasonable doubt, mere allegations, the onus should shift to INEC, which conducted the election, to prove that it has conducted the election in substantial compliance with the law. For instance, if you are arrested, Chamberlain, and God forbid, if you are arrested, and I can go to court on your behalf to say that Chamberlain was arrested at the Unity Fountain while a protest was going on, is currently being detained at the police headquarters. That is all that is required of me. The ownership to the police, or the State Security Service, EFCC, or any of them to show, Shambani should not have been there. He went beyond the call of duty, and we saw, maybe a weapon where he was standing. That was why we arrested him. So the onus is on the police to prove the legality of the detention or the arrest. And that is what we are saying. Once you can show that election was manipulated or rigged, the onus should shift to INEC to prove that we conducted the election, because INEC has the materials. All the materials. INEC has all the results. Why should I go to court to apply for the materials? So, and I think that is the basis of that suggestion.
Okay. So, when you also mentioned that, we should have special commission for prosecution of electoral offenses, are we also going to have special courts for electoral offenses? How should that play out?
No, we're not going to have special courts. For instance, during the last election, close to 2,000 suspects were arrested across the country. I'm aware, I think about 6 months ago, or no, about 3 months ago, INEC had already sent to INEC case files of over 200 suspects. And I'm aware, because INEC does not have the facilities to prosecute all of them, or them, INEC has entered into an agreement with the Nigerian Bar Association to have the suspect prosecuted. And what is being suggested is that there should be an electoral offenses commission, just like the EFCC, for the purpose of election, to go around and arrest all suspects, all persons that are disrupting elections or threatening elections, the conduct of good elections. At the end of the election, investigation will be conducted, and once the investigation is carried out, the Electoral Offences Commission will file the offenses in the appropriate court. So you don't need separate courts. They will be filed either in the magistrate court or in the high court. This is the recommendation of Ways panel.
Okay. Now, about the judiciary, I mean, we also have heard some who cases have gone against them, either in the House of Reps, Senate, even governorship. They say that there's been a lot of inconsistency in the principles in the judiciary now, with the judgments that have been handed down. Many of them are of the opinion that there's something not going right there, that even the precedents established in the judiciary is being abused, and something needs to be done. In fact, they fell short of saying there's a lot of corruption in the judiciary, and it needs to be addressed.
Well, again, we have advised colleagues who handle election petitions to advise their clients if they have no good cases, if they are bad cases. You don't have to go to court. Again, unless we all combine forces, unless we all decide to conduct good elections. I've said it repeatedly. Judges are not suited to decide the winners of election. Judges are bound by the evidence laid before them in deciding who won elections or who lost elections. So if a lawyer did not put before the court relevant materials, the court is not a Father Christmas, as is often said. The court can simply not decide, oh, we are giving victory to a person who has not been proved to have won an election. That is not to say that our judges, particularly the Court of Appeal, and even Election Petition Tribunal, in this age of internet, this age of technology, to circulate their judgments and ensure that there is consistency. And the question of technicality. I mean, you cannot but have technicalities. The law is about technicalities. But we're asking our judges to embrace justice, substantial justice, in a way that you cannot punish voters for the errors of INEC. And I think that was what recently happened in Kano, where 165,000 votes were said to have been annulled because they were not marked by INEC officials. What is my business as a voter? Is to go to the polling unit, collect the ballot paper, mark it, thumbprint, and then give to the INEC or throw it into the ballot box. So how can I now decide? I mean, how will I know whether it is marked by INEC or not? So you cannot punish. The courts are not empowered to punish voters because of the negligence of INEC officials. And it is so stated in the law that once the results have been counted, the results have been declared, once the votes have been counted, you cannot annul. You cannot challenge the validity of the ballot paper. So I think these are the areas that our judges will have to go back to the drawing table and ensure that substantial justice, is given to petitioners and respondents. But what is important? Let us conduct good elections. And I was just talking of the figures now. In 2015. We had few petitions because the election, based on the use of card readers then, it was difficult for those who were, people I call seasoned election riggers. It was difficult for them to inflate figures. And that is what the Beavers machine has also done, i.e. to have electronic accreditation of voters. Once you do that, you then ensure that results are transmitted to the central server of INEC. So what you need at the end of the day will be two reports. Reports of accreditation via Beavers machine and the results that have been transmitted by the INEC. Once you have those two reports, why should you be in a tribunal for 6 months to prove what? In Kenya, because the system has been technologized. Presidential election petitions are handled by the Supreme Court within 14 days. It is the same situation in Zambia. So I'm not talking of the United States or the UK. I'm talking of the development in Africa today. And we must move with time. We must lead the continent in delivering good elections. And that is doable. That is possible. Happily, the Senate just rose from a retreat in Uyo, Akwa Ibom State, where the senators resolved collectively that the Electoral Act be amended to allow or to make transmission of election results compulsory. I do hope that the House of Reps that will be meeting in Lagos, I think in the middle of this month, will also concur so that we can rush back to the National Assembly and have amendments of the Electoral Act. One, to have transmission of results, perfect the use of Beavers machines, conclude all pre-election matters before elections, conclude all election petitions before the inauguration of government, set up the Electoral Offences Commission to be able to deal with malfeasance or electoral malpractice. Once we can ensure that these basic recommendations are carried out, we can then confidently, prepare for the 2007 elections or the elections that will be held between now and 2007. 2027. What?
I guess you mean 2000, excuse me, I think you mean 2027 Mr. Falana. But I guess the message is already passed across, and it's good to see that the Senate is thinking in that direction.
Yes.
But I'd like to visit again the appointment of these resident electoral commissioners, and you have confirmed that you have been able to identify at least 4 partisan people. These names have been making their way on social media with hard evidence. But there's some people who will say, oh, that it's also possible that they have resigned their membership of these political parties. Some people have faulted the fact that there is nothing in our laws that provides a moratorium, a period whereby people must have been non-partisan for a while before they are appointed into political offices. And then there are some people who also say, look, somebody might be wearing a political party uniform, which is everybody now knows at least maybe where that person's loyalty might lie, but it doesn't mean that the person cannot be neutral. Some people make that argument, and some people say, oh, where you also have people who are purportedly neutral but are doing things that favor a political party, shouldn't we just as well know that we're populating the place maybe with equal number of political representatives from each political party, instead of saying that, oh, we're doing away with political alignment, and we have people who are neutral, who are truly not neutral. Do you think that we've truly considered all of the options when it comes to the appointment of our resident electoral commissioners?
Well, the amendment of the Constitution to the effect that only independent people, non-partisan persons, will be appointed as electoral umpires was based, that recommendation, the amendment was anchored on our experience, whereby those who resign and become resident electoral commissioners or national electoral commissioners betray the country in the past. And you can't just say, oh, whereas I was a member of a political party up to yesterday. Today now, I moved to become a resident electoral commissioner or a national electoral commissioner. Therefore, I will forget my alliance to my former political party. I will then become totally neutral when the country has produced in all the states of the Federation good people, independent-minded people, people of integrity, who can conduct good election. And the whole idea is this: once you apply to be a resident electoral commissioner or a national commissioner, the law says, Way's recommendation is that your CV should be published, you apply, and then the members of the public will find out who you are. For instance, if a lecturer was in the habit of selling marks, it doesn't have to belong to a political party. He now says, please, I want to be a rec or a national commissioner of finance. Oh, some student will say, sorry, you were selling marks to us. So if you become a resident electoral commissioner, you are likely to sell votes. And this is the whole idea.
I think that is taken. So would you say then that the Senate even breached its own rules? Because from what we understand, the practice is that these names ought to have been referred to its committee on electoral matters, but they didn't go there. Now, when we spoke with the Senate spokesperson yesterday, he said, oh, it was because the Senate Committee of the Whole wanted to consider those names in totality, and they wanted to give the entire Senate the benefit of the doubt to be able to ask them questions. But there are those who have also raised questions about the speed with which these resident electoral commissioners were confirmed. The names are presented on Tuesday, and by Thursday, all 10 of them had been confirmed,
no,
would you say that the Senate breached its own rules,
no, for
its
sure.
own processes,
for sure,
in terms of how it went about the confirmation of these commissioners?
What Senator Akpabio did, having realized the allegations against some of the resident electoral commissioners, particularly 4 of them, he decided not to allow the committee to have a say, because those who have petitions against them were rushing to the committee, hoping that the committee will listen to them before recommending to the General House, the plenary. But what happened this time was that Senator Akpabio decided to waive and simply invite the nominees to the plenary session, and without considering the petitions, including affidavits. The nominees were simply, as usual, take a bow. But again, as I said, that is not the end of the matter. Just yesterday, the PDP in Akwa Ibom State has gone to court, and I do know that there is an electoral alliance group of civil society organizations that are also going to court any moment from now. Because we must get it right this time around. No sentiment this time around. Because we can't go on like this. We can't go on interminably. You can't go on like this. And that is why this time around, every aspect of the electoral process will have to be taken very seriously. That is the position.
Yesterday, the People's Democratic Party, as a political party, held a press conference on this matter, decrying what had happened on the floor of the Senate. But then there are questions as to what exactly the role of the opposition is. Because people have also asked questions as to why it was that, the generality of the Senate looked like they endorsed what had happened on the floor of the Senate. There was not one objection on the floor of the Senate yesterday. Did you feel anyhow in terms of, how that passed without any objections on the floor of the Senate, not even from members of the opposition?
In the Second Republic, what happened was that you had political parties. They were ideologically based. At that time, the UPN of the late Obafemi Awolowo and PRP of Aminu Kano worked together in the National Assembly and opposed unpopular policies of the MPN, the ruling MPN, and the MPP. At a stage, GMPP of Ibrahim Waziri joined the 2 other progressive parties. Today, there is ideological, in fact, ideology is gone in the National Assembly. So they are in alliance. And that is why, in fact, the few dissenting voices from the Senate have come, very few, from the ruling party. I remember, I recall an instance where I think it was only Senator Adams Oshiomhole that challenged the appointment or the policies of central bank governors in Nigeria. Now, the opposition parties, some of the senators felt, oh, why is this guy disturbing us? Oh, does he think he's still a labor leader? So, in the National Assembly, unless Nigerians rise up, unless Nigerians decide, and I think that was what happened yesterday. I think one of the items in the supplementary budget, because of the general popular opposition to it, the House of Reps, of course, the Senate as usual had passed it, but the House of Reps, sorry, we have to move this to the a student loan or whatever. So we must be very vigilant. Nigerians must wake up regardless of political affiliation and ensure that we have good elections, we run the economy properly in the interest of our people. But if you are expecting members of the opposition in the Senate or the House of Reps to bail Nigeria out of crisis, you may have to wait for too long.
All right, there's this recommendation by Justice Dattijo on the representation in Supreme Court. I'd like you to listen to it, and then let's get your perspective on what he says.
As the justices who hear these matters are grossly overstretched and able to meet the demands of their onerous assignment, the litigants who approach the court seeking justice are left in limbo, waiting endlessly for justice to be served. These, as I have said before, are avoidable. While I exit today, the North Central Zone that I represent ceases to have any representation until such a time new appointments are made. My Lord Honorable Justice Ejembi Eko, JS, who also represented the zone, retired on the 23rd of May 2022. My Lord Honorable Justice Sylvester Mwani Mbuta, JS, died on the 7th of March 2021. I repeat, 2021. There has not been any appointment in his stead for the Southeast. To ensure justice and transparency in presidential appeals, thank God they have been hard and determined. All geopolitical zones need to be represented. They are required to participate in the hearing of such appeals. It is therefore dangerous, or it was therefore dangerous, for democracy and equity for two entire regions to be left out in the decisions that affect the generality of Nigerians.
How do you respond to that, Mr. Falana? All regions of Nigeria to be represented at the Supreme Court?
The way I look at it is this. And I made this point here sometimes. We must run the country on the basis of rule of law. We just discussed the appointment of Resident Electoral Commissioner. What does the law say about it? Every appointment, what does the law say about it? The Constitution provides that the full complement of the Supreme Court will be 21 justices. We've never met, that figure. What then happens? Each geopolitical zone in the country has a number of justices, or should have a number of justices in the Supreme Court. So that's what the law provides. I mean, that's a practice. Why have we not filled the vacancies is the issue. We've raised it, lawyers have raised it. In my own case, I blame my colleagues who are members of the Federal Judicial Service Commission and the National Judicial Council for not insisting that those vacancies be filled. Because that's why you have lawyers there and members of the public. Having said that, I'm also aware that the process for filling the vacancies in the Supreme Court has been put in place for some time, but the process has been very slow. Now that the number has been reduced to 10 justices, to avoid a constitutional crisis, the NJC must move speedily to fill those vacancies.
What's the process?
The crisis that can occur is if you have a situation where 4 out of the remaining 10 justices decline to sit on the case, maybe because they are taking part in the matter at the Court of Appeal, or for ties, family ties with the parties, then you are going to have a constitutional crisis where you are supposed to have a panel of 7 justices. Mama won't worry. And I will also want to challenge our judges. All our judges. Don't wait until you're retiring. Until you are retiring. Don't wait until you are going to give a valedictory speech. While you are there, insist on the necessary changes that should be carried out. Insist, even if you are going to cause a crisis for the system, to have those vacancies filled. Because like His Lordship said, some of those vacancies occurred 2-3 years ago.
Well, you said the other time that the process is slow. What is the process for, filling up those spaces, and who is supposed to take the lead? And
the process is that you start from the Federal Judicial Service Commission, right? Recommendations are made to the Federal Judicial Service Commission. Recommendations are made to the National Judicial Council. Once the candidates are okayed, then the names will go to the president. I think there was a time, about 5 years ago, whereby a number of judges were to be appointed. But for a year, they were not sworn in. Because the system was waiting for others. Right? So the point I'm making therefore is, this should be the last time that we are waiting for a judge to retire before filling his place. Once we can put in place a system that will compare the two bodies, Federal Judicial Service Commission and National Judicial Council, to set the engine in motion for filling vacancies and not wait for 2-3 years. We won't have this problem.
Is that to say that we don't have the system?
No, we have a system, but I'm saying that it's slow. And I'm saying, let us all go back to the Constitution and the relevant law. There is the Federal Character Commission Act. And I've said it before, if we have 2 positions, one must go up, one must come there. If there are 4, 2. If there are 6, 1 per geopolitical zone. And if you are going to have, that has been the experience in the Supreme Court, 4 justices per geopolitical zone, then you have the Chief Justice to make the number 21. But what will interest you? Again, it's not about really where you come from. Because those who may want to criticize His Lordship may also say, even in the presidential election, the 3 justices, including the Chief Justice from the Southwest, did not sit on the panel. So it's not about ethnic representation. It's actually about complying with the law by ensuring that all parts of the country are represented in the Supreme Court at all times.
So many other things to bring up, but we are completely out of time at this time. Thank you so much for being here this morning. Mr. Femi Falana is Senior Advocate of Nigeria.
Thank you very much.
Well, there is another issue when we return from this break. Do stay with us.